But yesterday, your lordship wanted me to examine whether 161 statements recorded by the investigator could be made use of by the accused when he invokes the jurisdiction of the court under 482, seeking quashing of the charge, the FIR, and the order of issuance of process. But in the Supreme Court, my lord, speaking through Honorable Justice, say in one sentence, statement under section 161 cannot be looked into is the observation. But earlier judgments and later judgments subsequent to that 2020, my lord, I have been able to lay my hands upon it. Straight away, I can invite my lord's kind attention to more than one judgment on the point. Before I take your lordship to those judgments, my lord, let me submit your lordship one thing. Please do not mistake me that I am going to the fundamentals. Please do not mistake me.
No, that's all right. So what?
Lord, your lordship is certainly aware of all these things.
Sir,
But,
no, sir, that's not there. Sometimes we may also fumble on fundamentals. Yes.
But the court would take cognizance under section 190. It leaves the note. Your lordship has ruled in several cases. If it is a private complaint, my lord, it would be under 190, 1A. But if it is a police report, under 190, 1B. If it is on any other information which the court would get, it would be under 190, 1C. Well, now in this present case, we are only concerned with the court taking cognizance of an offence under section 190, 1B because it is on the basis of a police report that has been given. Well, may I just request your lordship to just refresh my lord's memory. Have a look at under section 2R of this. In fact, your lordship has referred to it in the umpteen number of cases. Well, have a look at section 2R first.
Yes.
Well, what is police report?
Yeah.
Well, 190, 1B refers to the court taking cognizance on a police report.
Yes.
Have a look at police report as defined under section 2R of the CRPC. Police report means a report forwarded by a police officer to a magistrate under subsection 2 of section 173.
Yes.
It is on the basis of this report, my lord, the trial court would take cognizance of the offence, whatever may be the offence. We are
Yes.
not on that issue now. Well, now may I request your lordship to kindly go to 173 subclause 2. Have a look at 173 subclause 2. Well, 173 subclause 2 would say, every investigation under this chapter shall be completed without unnecessary delay. Subclause 1A. The investigation, we are not concerned with that, 376 and all that. Now subclause 2. As soon as it is completed, the report of police officer and completion of investigation. This is the police report that is defined under section 2R, 173 subclause 2. As soon as it is completed, the officer in charge of the police station shall forward to a magistrate empowered to take cognizance of the offence on a police report, a report in the form prescribed by the state government, stating, number 1, the names of the parties, the nature of information, the names of persons who appear to be acquainted with the circumstances of the case, whether the offence appears to have been committed and if so, by whom, whether the accused has been arrested, whether he has been released on bond, whether he has been forwarded in custody, whether they report medical examination, etc. But the police report as mandated under section 173(2) should contain all these things, including the statements of witnesses who are acquainted with the facts of the case. Well, it is on the basis of the police report that is found under section 173(2) of the court, the magistrate would take cognizance. So for the purpose of taking cognizance, indeed, the magistrate is bound to advert to the evidence which the investigator had collected, which are enumerated under section 173(2) of the CRPC, without which he could not have taken cognizance of the offence at all. 161 statement or the statement that is recorded under section 161, statement that is recorded under section 164, would form part of the police report as defined under 2R. for the purpose of taking cognizance of the offense would be my first respectful submission. Well, without which he can't look into it at all. Without which he can't make out whether an offense has been made out or not. Well, then kindly imagine the situation, Miller. He files a charge sheet. Well, a charge sheet contains the statements of witnesses, be it under 161, be it under 164, in addition to other documents which would be collecting. Well, in order to seek the benefit of an order of discharge, or the prosecution to seek the benefit of an order directing framing of charges against the accused, but he has got to advert to the police report and the record of the case, be it under section 227 or under section 239. 239 refers to the cases triable by a magistrate, and 227 refers to the cases triable by the Court of Sessions. What needs to be seen for the purpose of either framing of charges or for the purpose of passing an order of discharge, my lord, is the record of the case, which includes all these things, a police report. My lord, this 161 forms part of the police report, but the magistrate could look into it for the purpose of proceeding to frame a charge or passing an order of discharge. If the Sessions Court is entitled to look into it, can we say or can we contend, can the prosecution contend that this honorable court in exercise of its jurisdiction under 482 cannot look into the police report, which includes the statements of witnesses recorded under section 161 of the CRPC? Well, it is only on the basis of the statements of witnesses recorded, it would become possible for the investigator to formulate an opinion with regard to the commission of the offense or not, so that the accused is sent before the court to take his trial in the case. Well, and now, may I invite my lord's kind attention to the judgment of the Supreme Court in 1983 Supreme Court cases 152 paragraph. Our ಕೊಟ್ಟಿದ್ದೀರಾ copy? Professor, I have received the copy. ಕೊಡಿ ಅವರು ಕೊಡಿ.
One copy.
May I request your lordship to kindly turn to paragraph 5, which your lordship would find at page 195. This was under Essential Commodities Act.
Ink page 195.
Ink page 195. Well, it commences at 192. Kindly go to ink page 195, paragraph 5. My lord, since this is an important legal issue,
Yes.
which my lord wanted some clarification, that is why, my lord, I am dealing with it at
Yes.
length. Section 10A of the Act provides that notwithstanding anything contained in the Code of Criminal Procedure 1973, every offense punishable under the Act shall be cognizable, which would imply that an officer in charge of a police station, on receipt of the information of such cognizable offense, may, without the order of a magistrate, investigate into the offense according to the procedure prescribed in Chapter 12 of the Code. On completion of investigation, it commences from section 154, 155, 156, and all that. On completion of the investigation, the police officer shall submit a report to the magistrate empowered to take cognizance of the offense on a police report. The report has to be in the prescribed form, and the details to be mentioned in the report are specified in section 173(2). While submitting this report in connection with the offense to which section 170 of the code applies, meaning thereby that a case in which such investigating officer has found sufficient evidence for a trial to be held by the court, it is incumbent upon such officer to forward to the magistrate, along with his report, A, all documents or relevant extracts thereof, and with the prosecution proposes to relay, other than those already sent to the magistrate during investigation, and B, mark this, my lord, the statements recorded under section 161 of all the persons whom the prosecution proposes to examine as the witnesses. My lord, this police report, the statements of the witnesses you would have recorded during the course of the investigation forms part of the police report. Now, may I request your lordship to kindly turn to paragraph 9 at ink page 198. My lord gets it. Section 173(2)(1) provides that on completion of the investigation, the police officer investigating a cognizable offence shall submit a report in the form prescribed by the state government, stating therein the names of the parties, the nature of information, the names of persons who appear to be acquainted with the circumstances of the case. That is the statements of witnesses under 161. Whether any offence appears to have been committed, and if so, by whom, whether the accused has been arrested, whether he has been released on his bond, and if so, whether with what sureties, whether he has been forwarded in custody under section 170, subsection 5, section 173, makes it obligatory or relevant extract thereof, and with the prosecution proposes to relay and mark this, the statements recorded under section 161 of all the persons whom the prosecution proposes to examine as witnesses at the trial. Well, this forms part of the report of the investigator as found under section 191B as well as under section 173 to be managed. Now kindly read the next paragraph, my lord. Section 173(2) thus provides what the report in the prescribed form should contain. In this case, the report did contain the name of the accused and the nature of the offense. In fact, section 170 provides that if upon an investigation under chapter 12, it appears to the officer in charge of the police station that there is sufficient evidence or reasonable ground to proceed against the accused, such officer shall forward the accused in custody to a magistrate empowered to take cognizance of the offence upon a police report. If the accused is on bail, that fact will be notified in the final report submitted under section 173(2). Therefore, the statutory requirement of the report under section 173(2) would be complied with if the various details therein prescribed are included in the report. This report is an intimation to the magistrate that upon investigation into a cognizable offence, the investigating officer has been able to procure sufficient evidence for the court to inquire into the offence and necessary information is being sent to the court. In fact, the report under section 179(2) purports to be an opinion of the investigating officer that as far as he is concerned, he has been able to procure sufficient evidence for trial of the accused by the court. And when he states in the report that not only the names of the accused, but names of witnesses, the nature of offense, and a request that the case be tried, there is compliance with section 173(2). The report as envisaged by section 173(2) has to be accompanied as required by subsection 5 by all the documents and statements of witnesses therein mentioned. Well, the result of the opinion which he formulates is the one that your lordship would find in column number 17 of the pro forma charge sheet. That opinion, my lord, is based on the evidence which he would have collected during the course of the investigation of the crime. For this court to find out whether the opinion which he has given as found in column number 17 of the pro forma charge sheet, is it correct? Is it wrong? Is it right? Is it acceptable or not? What needs to be seen is the evidence which he has collected. But that would be my submission. Well, now let us go to the next sentence, my lord. One cannot divorce the details which the report must contain as required by subsection 5 from its accomplishments which are required to be submitted under subsection 5. The whole of it is submitted as a report to the court. Well, I think the rest of the things we can skip. This would be my first submission. Well, now may I request your lordship to kindly turn to the case in 1954, volume 2, Supreme Court cases 934, which your lordship would get at ink page 211. May I request your lordship to kindly turn to paragraph 8, my lord, at page 227. My lord gets it.
Yes.
Thus, under the code, investigation consists generally of the following steps: proceeding to the spot, ascertainment of facts and circumstances of the case, discovery and arrest of the suspected offender, collection of evidence relating to the commission of the offense, examination of various persons, including the accused, and the reduction of their statements into writing if the officer thinks fit. Well, that is the only thing that is relevant for the purpose of this case. Well, therefore, my respectful submission to your lordship is a combined reading of the provisions of section 2R, 173 subclause 2, and the law laid down by the apex court in more than one judgment, well, would give us an indication that the statements the investigator during the course of the investigation of the crime should collect evidence. He would be collecting evidence by recording the statements of witnesses who are acquainted with the facts of the case. And those statements that are recorded, be it under 161 or under 164 of the CRPC, would form part of the record of the case in as much as it becomes part of the final report which he would be filing. And the opinion which he would be arriving at is based on the evidence which he would have collected. And that is the one that is found under column number 17. And that opinion is put into test. But your lordship would be examining whether that opinion is right or wrong on the basis of the evidence which he had collected. Therefore, my lord, I am required to invite my lord's kind attention to the evidence which the investigator has collected, since I had sought for the quashing of the charge sheet in this case.
Yes.
What do you Cyber Gutta Wayne's case, my lord.
Conclusion can be assured.
That's what I submitted. Yes, no, correct. Well, and ultimately, I'm sorry.
Yes, sir.
Well, and ultimately, my lord, your lordship could certainly eschew the opinion of the investigator in the event that the investigator has come to a wrong conclusion or a wrong opinion after examining the evidence which he has collected. Well, that is what the Supreme Court has said in Bain's case. Well, your lordship may kindly turn to page 202, ink page 202. This is in 1980, volume 4 Supreme Court cases.
Shallow breathing, chest breathing, and mouth breathing are the worst breathing habits that limits your oxygen flow and
631. May I request your lordship to kindly turn to ink page 200, paragraph 6. It is seen from the provisions to which we have referred to in the preceding paragraph that on receipt of a complaint, the magistrate has several courses open to him. He may take cognizance of the offence and proceed to record the statements of the complainant and the witnesses present under section 200. Thereafter, in his opinion, if in his opinion there is no sufficient ground for proceeding, he may dismiss the complaint under section 203. If in his opinion there is sufficient ground for proceeding, he may issue process under section 204. However, if he thinks fit, he may postpone the issuance of process and either inquire into the case himself or direct an investigation to be made by a police officer or such other person as he thinks fit for the purpose of deciding whether or not there is sufficient ground for proceeding. He may then issue process if, in his opinion, there is sufficient ground for proceeding or dismiss the complaint. If there is no sufficient ground for proceeding, on the other hand, in the first instance, on receipt of a complaint, the magistrate may, instead of taking cognizance of the offence, order an investigation under 156(3). The police will then investigate and submit a report under section 173(1). On receiving the police report, the magistrate may take cognizance of the offence under section 191(b) and straightaway issue process. This he may do irrespective of the view expressed by the police in the report, whether an offence has been made out or not. The police report under section 173 will contain the facts discovered or unearthed by the police and the conclusions drawn by the police therefrom. The magistrate is not bound by the conclusions drawn by the police, and he may decide to issue process even if the police recommend that there is no sufficient ground for proceeding further. The magistrate, after receiving the police report, may, without issuing process or dropping the proceedings, decide to take cognizance of the offence on the basis of the complaint originally submitted. So it is not incumbent for the court, my lord, to accept the opinion which the investigator would have expressed in column number 17, which in his wisdom is based upon the evidence which he would have collected. May I now request your lordship to kindly go to paragraph 7. In Abhinandan Jha's case, what the Supreme Court has said, your lordship would get it. Paragraph 7. In Abhinandan Jha, the question arose whether a magistrate 173(1) had been submitted to the effect that no case had been made out against the accused, could direct the police to file a charge sheet on his disagreeing with the report submitted by the police. This court held that the magistrate had no jurisdiction to direct the police to submit a charge sheet. It was open to the magistrate to agree or disagree with the police report. If he agreed with the report that there was no case made out for issuing process to the accused, he might accept the report and close the proceedings. If he came to the conclusion that further investigation was necessary, he might make an order to that effect under section 156 subclause 3. If ultimately the magistrate was of the opinion that the facts set out in the police report constituted an offence, he could take cognizance of the offence, notwithstanding the contrary opinion of the police expressed in the report. He can certainly, I would rather say, reject the opinion which came to be expressed and take cognizance of the offence. Therefore, my respectful submission to your lordship is the police report is the one that is submitted under 173(2) of the CRPC. That report should contain, my lord, the statements of witnesses recorded under section 161 or under section 164. But it is indeed not only for the purpose of taking cognizance of the offence, but also for the purpose of issuance of process against the accused, as well as for the purpose of consideration of the request of the accused for an order of discharge or the request of the prosecution to proceed to frame a charge if the magistrate is indeed required to examine the record of the case, the evidence collected by the investigator, but the prosecution cannot contend before your lordship that the statements recorded by the investigator under 161 cannot be adverted to, would be my respectful submission. Well, may I now invite your lordship's kind attention to the first judgment of the Supreme Court, and then I shall take your lordship to the latest judgment of the Supreme Court, which is subsequent to 2020. Well, the first judgment of the Supreme Court on this point is that is in 2013, Rajiv Thapar's case. I'm sorry. Rajiv Thapar's case. May I request your lordship to kindly turn to paragraph 29. Kindly go to paragraph 29.
Yes.
This Rajiv Thapar is in 2013, volume 3, Supreme Court cases 330. Kindly go to paragraph 29 and onwards. Kindly permit me to take your lordship first to paragraph 29.
Yes.
Well, this was under 482.
Yes, sir.
That is after the charge sheet. Quashing of the charge sheet.
Yes.
The issue being examined in the instant case is the jurisdiction of the High Court under section 482 of CRPC.
Yes.
Page 250.
Yes.
I'm sorry. The issue being examined in the instant case is the jurisdiction of the High Court under section 482 CRPC if it chooses to quash the initiation of the prosecution against an accused at the stage of issuing process or at the stage of committal or even at the stage of framing of charges. These are all stages before the commencement of the actual trial. The same parameters would naturally be available for later stages as well. The power vested in the High Court under section 482 of CRPC at the stages referred to here and above would have far-reaching consequences, and as much as it would negate the prosecution/complainant's case without allowing the prosecution complainant to lead evidence. Such a determination must always be rendered with caution, care, and circumspection. To invoke its inherent jurisdiction under Section 482 CRPC, the High Court has to fully satisfy that the material produced by the accused is such that would lead to the conclusion that his/their defense is based on sound, reasonable, and indubitable facts. The material produced is such as would rule out and displace the assertions contained in the charges leveled against the accused. And the material produced is such as would clearly reject and overrule the veracity of the allegations contained in the accusations leveled by the prosecution/complainant. It should be sufficient to rule out, reject, and discard the accusations leveled by the prosecution complainant without the necessity of recording any evidence. For this, the material relied upon by the defense should not have been refuted, or alternatively cannot be justifiably be refuted, being material of sterling and impeccable quality. The material relied upon by the accused should be such as would persuade a reasonable person to dismiss and condemn the actual basis of the accusations as false. In such a situation, the judicial conscience of the High Court would persuade it to exercise its power under Section 482 of the CRPC to quash such criminal proceedings, for that would prevent abuse of process of the court and secure the ends of justice. But the material on which I am placing reliance is the one which the investigator himself has collected. It is not that I am producing some other evidence. Based on the factors canvassed in the foregoing paragraphs, we would delineate the following steps to determine the veracity of the prayer for quashment raised by the accused by invoking the power vested in the High Court under Section 482. Well, at step 1, whether the material relied upon by the accused is sound, reasonable, and indubitable, that is, the material is of sterling and impeccable quality. Step 2, whether the material relied upon by the accused would rule out the assertions contained in the charges leveled against the accused, that is, the material is sufficient to reject and overrule the factual assertions contained in the complaint, that is, the material is such as would persuade a reasonable person to dismiss and condemn the factual basis of the accusations as false. Step 3, whether the material relied upon by the accused has not been refuted by the prosecution/complainant, because they can't refute it. That is the evidence or the material which they have collected during the course of the investigation of the crime. It is their material and it is not my material actually. And the material is such that it can't be justifiably refuted by the prosecution. Step 4, whether proceeding with the trial would result in an abuse of process of court and would not serve the ends of justice. If the answer to all these steps is in the affirmative, the judicial conscience of the High Court should persuade it to quash such criminal proceedings in exercise of the power vested in it under Section 482 of the CRPC. Such exercise of power, besides doing justice to the accused, would save precious, otherwise be wasted in holding such a trial, as well as proceedings arising therefrom, especially when it is clear that the same would not conclude in the conviction of the accused. But at this judgment, the law laid down by the Supreme Court in this Rajiv Thapar's case came to be followed in the subsequent judgment of the Supreme Court. Well, at that your lordship would get, in the case of Haji Iqbal, from, especially when it is clear that the same would not conclude in the conviction of the accused. But at this judgment, the law laid down by the Supreme Court in this Rajiv Thapar's case came to be followed in the subsequent judgment of the Supreme Court. Well, at that your lordship would get, in the case of Haji Iqbal, this is in 2023. Well, subsequent to this 2020. 2023, SEC Online, SC 946, Haji Iqbal alias Bala. Well, may I request your lordship to kindly turn to page 287 of my compilation. Kindly go to para 8 and
We will-
50.
we-
I'm sorry,
We will continue, right? We have the consent to continue?
well, it will take some time.
No, that's all right. If you have the consent to continue of all the parties, I will continue. Otherwise, sometimes what is happening in the court and
Saku. For the day, my lord, if my lord
No, no
permits,
problem. I have no problem.
I will stop.
Even if it is 6:30, I have no
ನಮಗೆ-
problem.
ನಾವು ಬೆಳಗ್ಗೆಯಿಂದ
ಬಟ್
ಇದೀವಲ್ಲ.
ಅದು ಪರವಾಗಿಲ್ಲ ಇಲ್ಲಿ ನಮ್ದು ಬಿಟ್ಬಿಡಿ. ಆಮೇಲೆ ಅನ್ಡ್ಯೂ ಇಂಟ್ರೆಸ್ಟ್ ತೋರಿಸಿದ್ರೆ ಆಫ್ಟರ್ 4:45
Your lordship may have it on some other day.
ನೋ ವಿಲ್ ಕನ್ಸೆಂಟ್ ಇದ್ರೆ ಐ ವಿಲ್
ಇಲ್ಲ,
ಕಂಟಿನ್ಯೂ.
ನಾನು ಆಗೋದಿಲ್ಲ. ಇನ್ನು ಸಿಕ್ಕಾಪಟ್ಟೆ it takes a lot of time, my lord.
ನೀವು ಹೇಳಿ.
Because my lord has raised an important and serious legal issue.
ನೋ ಪ್ರಾಬ್ಲಮ್ ಬಟ್ ಯು ಕಂಟಿನ್ಯೂ.
Then I have to take your lordship to the facts. Because yesterday, abruptly I stopped it because of your lordship wanted some clarification on the legal issue.
No, I have no problem to sit even up to 9 o'clock, provided you have no problem and all of you have consent to it.
Your lordship may have it on some other day.
ನೀವು ಕಂಟಿನ್ಯೂ ಮಾಡಿ, ಹಂಗೇನಿಲ್ಲ. ಐ ಆಮ್ ನಾಟ್ ಸೇಯಿಂಗ್ ಐ ವಿಲ್ ಸ್ಟಾಪ್.
No, I am requesting your lordship.
Tomorrow it should not be said that I have
No, I am
beyond
request-
court hours.
I am requesting your lordship to.
Shown undue interest to this, not all that. That is why.
ನಾಳೆ ಮಾಡೋಣ.
ನಾಳೆ ಬೆಂಚ್ ಇದೆ, I doubt.
Immediately after vacation.
ನಾಳೆ ಬೆಂಚ್ ಇದೆ.
ಗೊತ್ತು.
I don't know.
ನೋಡಿದನು. Immediately after vacation. Any day that suits my lord and friends, your lordship's convenience and my lord and friends' convenience. It takes some time, my lord. In fact, my lord and friend, Mr. Balan, also wants about 1 hour's time. And, alva, the special prosecutor also wanted about 40. ಅದಕ್ಕೋಸ್ಕರ
They consider only the state. not
ನಾನು ಹೇಳಿದೆ ಸರ್,
the-
ಕೊಡಿ ಅಂತ ಕೊಡಿಸ್ತೀನಿ.
ಕೊಡೋದೇ ಇಲ್ಲ ಅವ್ರು.
ನಾನು ಕೊಡ್ತೀನಿ, ತಗೊಳ್ಳಿ ಸರ್. ವೈ ಆಲ್ ತಗೊಳ್ಳಿ ಸರ್, ಅಂದೇ ಕೊಡ್ತೀನಿ, ತಗೊಳ್ಳಿ ಸರ್.
ಇಲ್ಲ ಕೊಡೋದಿಲ್ಲ, ಕೇಳಿದ್ರೇನು ಕೊಡಲ್ಲ ಅವ್ರು.
ಕೊಡ್ತೀವಿ ಬಿಡಿ ಸರ್, ಡೋಂಟ್ ವರಿ ಸರ್. That is not quarrel and small. You take it from me, I will give you.
Sure.
Your
And we
lordship,
will have it on the 6th,
Ah,
reopening day.
please, please,
Because tomorrow bench ಇದೆ, I don't know about single sitting.
please. Let.
Heard the learned senior counsel, Shri C.V. Nagesh, appearing for the petitioner. The matter was in fact heard yesterday at length and is continued today. Again, the parties are heard at length. The learned senior counsel, C.V. Nagesh, submits that he would require another, how much time?
Minimum 1 hour.
Would require another 60 minutes to minimum 60 minutes to complete his
So Balan
submission.
also wants.
The learned.
Only 1 hour, ತಮ್ದು 1 more hour.
Learned counsel, Balan appear, sorry, B. Balan, alla?
Yes, Bala.
Yes, Balan appear, Balana, Balakrishnan.
Full name Bala.
Full name ನಾವು ಪ್ರೀತಿಯಾಗಿ ಕರೆಯೋದು ಬಾಲನ್ ಅಂತ. Because we are
Balakrishnan
practicing in the
seeks,
magistrate court together.
Also, would also
Joseph
submit,
Officer ಇದ್ದಾಗ.
ಅಂತ ಇದ್ದಾರೆ madam,
ಅಲ್ವೇ?
would also submit that he would require an hour's time. The special public prosecutor also would, he would require 1 hour.
All depends.
Would also require 60 minutes to refute the submissions of the learned senior counsel, C.V. Nagesh. Due to paucity of time and the ensuing winter vacation, the matter is directed to be listed on 6th January 2024 at 2:30
25.
p.m. No, it's 2025
ಹೊಸ ವರ್ಷಕ್ಕೆ ಬಂದ್ಬಿಡ್ತೀವಿ.
at 2:30 p.m.
Please.
Interim order of any kind subsisting as on today shall continue till the next date of hearing in the light of the fact that the matter is being heard at large. Yes.
Please.
Reopening day ಬದಲು next day.
It's 7th, no problem.
7th.
7th at 2:30 p.m.
ಯಾವತ್ತು ಅನುಕೂಲ ಆಗುತ್ತೋ ಅವತ್ತು.
Yes,
2:30.
2:30.
Please. Deeply obliged.
ಅವ್ರು ತಗೊಂಡ್ಬಿಡಿ ಮೇಡಮ್. ವೀರಭದ್ರ ನಿಮ್ದು ಯಾವ್ದು?
ಇಲ್ಲ ರಾಜಗೋಪಾಲ